Good afternoon, everyone. Just to introduce myself, my name's Aditi. I'm a senior associate in the commercial property team, and I'm based in our Watford office. My session is on heads of terms, and over the years, we've had a huge amount of landlord and tenant work, and I've seen countless copies of heads of terms, and I thought it would be useful to go through what, as a lawyer, would constitute a good set of heads of terms. As Ellie said, if you have any questions as we go along, pop them in the chat, and we'll try and get to these at the end. Agents and brokers are particularly skilled in getting many of these headline points agreed at the outset. So the general advice would be the more that can be agreed at the outset, the faster the process will be for the client once it's been handed over to their legal team for drafting. If I could have the next slide, please. So what are heads of terms? Heads of terms aren't legally binding in most instances, but they set out the intention of the parties and the key terms. The main purpose is to set out in writing what these terms are for the transaction so that there's no room for misunderstanding later on. It can help to create an awareness of expectations on either side, and it also sets out the timeframes for the deal. Next slide, please. So I'm going to run through the key components of what I think makes a good set of heads of terms. Obviously, we're going to start with the parties. The heads of terms should always include who the parties are. Often we see heads of terms where the client is using an SPV that has yet to be incorporated, which is fine, but we would encourage that this detail is included as a note in the heads of terms, so we don't lose time in trying to locate this company at Companies House and/or onboarding an incorrect entity if they're a new client. Similarly, if the entity is already incorporated, a company number should always be included for completeness, as companies often have very similar names at Companies House. For the property, a full description of the property should be included. Where possible, always include a title number, as that can be really helpful for us. And if it's a sale or a lease of part, a plan which the buyer or tenant can use to submit searches on. For us, this is often the initial source of delay because a buyer can't submit searches without a plan. And typically the local search time lag is at least a month. So ideally, we want to get a plan circulated at the outset. Next slide, please. The lease details. So the duration of the lease is a fairly obvious one, but often on renewals, it needs to be clear whether the renewal lease starts from the date that the previous lease expired, or if it already has, whether it starts from the day of completion. We need to think about whether the lease needs to contain an option to renew or an option to extend, particularly if it doesn't have 1954 Act protection. These are all things that we would expect that the heads of terms detail so that we haven't got this ambiguity when we come to drafting. In relation to rent, obviously, the heads of terms need to include the base rent, and we usually assume the rent is going to be paid quarterly in advance on the traditional quarter days. However, a lot of clients now have preferred rent payment dates, which are 1st of January, 1st of April, etc. So if these are the preferred dates, we would just ask that they're included in the heads of terms because it just prevents a nasty surprise at the point where we report to the client and the dates aren't aligned with their usual accounting dates. Next slide, please. Rent review. So rent review can often end up being a big point of contention. Usually we see something in the heads of terms that says 5-yearly rent review. We need clarity on the method of review. So is that going to be an open market review? Is it going to be stepped? Is it going to be index linked? And when these reviews are taking place? Often we'll see a combined review, so it might be the higher of these two things. So that kind of detail is always helpful to agree at the initial stages. If the lease is a 1954 Act protected lease, we should also be thinking about whether there's going to be a last day rent review as well, and this should also be detailed in the heads of terms. Rent review in relation to RPI shouldn't generally be included anymore, as RPI is set to be reformed and aligned with CPI, Consumer Prices Index, by 2030. So unless you're entering into a lease which has one single review before 2030, none of the rent reviews should be taking place by reference to RPI because that method may not exist at the review date. If your RPI or CPI is going to be limited with a cap or a collar, which is basically a maximum or a minimum amount that the rent needs to increase, these should also be detailed in the heads of terms. Next slide, please. Any additional costs and charges. So with service charge, this is an area where we end up going back and forth quite a lot because the service charge represents a substantial proportion of the money that the tenant's going to be paying for a particular premises. Ideally, the parties should have agreed in advance how that service charge is going to be calculated. Usually landlords are quite good and they will give an indication to the tenant of what the first year service charge might be. But is this by reference to a fair and reasonable proportion of the overall cost of services? Or is it a fixed percentage of the cost of services? Can that percentage be varied? Is it based on occupied floor area? Is it by reference to something else? And ideally, we would want a fixed percentage detailed in the heads of terms if that is what the parties have agreed. As a tenant, you might want to be excluding certain items from the service charge. For example, if you're taking a lease of some parking spaces within a retail park, you would not want an obligation to contribute towards services that cover the main buildings on the estate. So a tenant in that instance might be looking for exclusions on their service charge. And again, this should be set out in the heads of terms so that we're all clear. On insurance, again, the calculation follows the same as the service charge, whether that's going to be a fair and reasonable proportion or otherwise a percentage. Insured risk is one that comes up often. It's never mentioned in the heads of terms. And acting for a tenant, you would always include cover for insured risks. It's really helpful if this can be bottomed out early at the heads of terms stage because we can end up incurring quite a lot of time and costs in negotiating these sorts of clauses where the parties haven't thought about it in advance and then it comes up at the last minute. On outgoings and other costs, we generally assume that the tenant is responsible for outgoings, utilities and business rates. So to the extent that that doesn't apply, this should also be set out in the heads of terms. Often on short lets, we get an all-inclusive rent where the rent is inclusive of service charge, insurance, rates and things like that. So it is important that that is noted on the heads of terms if that's not the case. Next slide, please. A break clause. A break clause is often one that takes days, if not weeks, to negotiate. The break conditions should be set out very clearly. The usual one is payment of all rent, but we need clarity on whether that is rents as defined in the lease, or is it annual rent only? If it's rents, is that annual rent, service charge and insurance, or is that extended to interest and other sums that may have been demanded under the lease? As a tenant, you will want 100% clarity on the sums which you need to pay by the break date. So early agreement on this should be sought. Breach of covenant, is that a breach of all covenants, or is it just the covenant to repair and maintain the property, which we often see? Is it going to be a material breach? Does that breach have to be notified to the tenant in advance with an opportunity to remedy it? That kind of detail is always very helpful if it's possible. Vacant possession, this often creeps into heads of terms as standard, but actually vacant possession is a very, very strict test and is often not accepted by tenants on a break negotiation. The tenant will often want this watered down to the property being free of occupation and leaving behind no subsisting tenancies as well. So those are all things to think about when you're trying to get heads of terms agreed on a break. Next slide, please. Alterations. So heads of terms should be very clear on alterations. Often we find that some alterations are permitted and the heads of terms will say with landlord's consent. But the key here is to understand whether the landlord can reasonably withhold its consent and also in what circumstances it can withhold its consent. There may be circumstances where the tenant can't make any types of alterations to the property, or there may be instances where the tenant can make alterations without the landlord's consent entirely. If the tenant's going to go off and make alterations without landlord's consent and the landlord's not too bothered, does the tenant need to notify the landlord at all in the process or adhere to any sort of guidelines? Is the tenant obliged to provide the landlord with a set of plans at the end of their work so that the landlord has a record of these things? With yield up and restoration obligations, this should be carefully considered. If the tenant is being handed a unit in shell and core condition, would you as landlord want that returned in that state? Or if the tenant's doing a particularly helpful fit out, would you want to utilise some of that fit out at the end of the lease? And do you want to include that in the heads of terms to say that these works will remain and those works must be taken out? Next slide, please. The permitted use should be clearly defined, if possible, by reference to a use class, because then there's no ambiguity. And also consideration should be given to any other conflicts on use. For example, if you have a lease on an estate, to know if there are any other uses which the landlord is limited to. By way of example, I once acted for a restaurant operator opening a restaurant in a retail park, only for the landlord to realise halfway through the deal that since they had a letting to Pizza Hut elsewhere on the retail park, they were prohibited under the Pizza Hut lease to allow any other restaurant to serve pizza, which meant that my client wasn't able to serve its full menu and withdrew from the transaction. There should also be clarity on what changes of use are allowed and with what level of consent. There might be certain uses that the landlord is happy for the tenant to continue with without any further reference, but certain changes of use might require landlord's consent. We would encourage this to be included in the heads of terms as well. Repair is another pet peeve of ours. It should be clearly defined. If you've put a full repair obligation subject to a schedule of condition, that by default is a limited repair obligation. Acting for a tenant, you need to ensure that you've had a full building survey done if you're taking on a fully repairing lease. Otherwise, you could end up with a nasty bill at the end. This could end up with an agreement for lease being introduced as a precursor to the lease. If you've done your building survey and certain repairs are revealed, you'd be able to negotiate that the landlord perhaps carry this out at their expense as a precondition to the lease. Next slide, please. Legal and practical considerations. And we often get asked whether an exclusivity agreement is necessary. And the answer is, it really depends. Exclusivity can be really helpful to focus everyone's minds, but bear in mind, we can lose easily 2 to 3 weeks in negotiating the exclusivity agreement, the get out clauses, the mechanisms for non-refundable deposits. So it is worth thinking whether it's better to sometimes just get on with the deal if time is of the essence, or if you have time and or the deal value is higher, it's worth putting one in place. Termination rights is another thing that comes up. Usually it's the standard non-payment of rent, breach of covenant and insolvency. But for bespoke transactions, if there are situations where the landlord may want to forfeit the lease, these should also be included at heads of terms stage. Next slide, please. In conclusion, indicative timescales are helpful where specific deadlines have been agreed. The heads of terms are the base document against which the whole deal rests, and it can be an incredibly helpful tool when all parties are singing from the same hymn sheet. It should also help the lawyers to get the drafting done quicker and turn the documents faster. At the beginning, you should also be thinking about whether you will need any external advice. If you need tax advice, you can always come to us and we can direct you to the appropriate person. If you need a surveyor to advise you on the building, you should get these experts involved at the outset, and this will prevent delays down the line. Also, please don't forget that SDLT may apply to your lease, so please budget for that as well. That brings me to the end of my section, but like I said, if you have any questions, pop them in the chat and we will try to get through as many as we can at the end. I'm now going to hand you over to my colleague, Luke. Thank you.
Thanks, Aditi. So my name is Luke Exton, and I'm an associate in the commercial property team here at VWV in Bristol. I've also worked in construction law teams during my career, so hence the topic. I'm going to talk to you today about collateral warranties and their relevance in property transactions. I'm going to cover why we need them, what they are, who needs them and who gives them, and then cover some key clauses and then a brief note at the end on enforcement. So what do you do if you have them? I appreciate that some of you will know quite a bit. I don't know why the slides are going forward. That's fine, thank you. I appreciate that some of you will know quite a bit about collateral warranties and deal with them on a day-to-day basis. However, I also know that there'll be plenty of people here who are not very familiar with collateral warranties, and so I've tried to give a balance of covering the basics while, touching on some more complex points, but not too much. So why do you need them? So when it comes to construction projects, there are usually so many parties involved that a diagram like this, even though it feels a bit schoolboy, it does really help us understand the structure and where collateral warranties fit into it. So this is a very simple diagram, but and no doubt most of you will have dealt with much more complicated projects with a lot more different parties, but for our purposes, this should be fine. Starting at the top there, you can see a funder. So let's say they are funding the construction of a brand new building, and the employer below them owns the land and will be getting funding and running the show. When we say employer, we obviously don't mean an employer of staff. We mean the client or the developer, which would be terms you're much more familiar with. Essentially, they are the party who the construction works are carried out for. Now, each of the lines in this diagram you can see between the parties represents a document or an agreement or a contract entered into between those parties. So the line between the funder and the employer will be, the loan agreement or the funding agreement. Below the employer to the left, you've got the building contractor there. The line between the employer and the building contractor will be the building contract. I'm sure most of you will have heard of the JCT suite of contracts, which is the most common form of building contracts used in the industry, but also that you may have heard of NEC contracts as well, for example. The building contractor, as you'll probably know, will not do all the works themselves, and you'll see a line below them to the subcontractors. They'll appoint them individually under individual subcontracts, and they'll carry out different elements of the work. So you're going to get roofing subcontractors, maybe a lift subcontractor, and the list goes on and on. On the right there, you can see the professional team. Now, the employer will usually need to appoint many professional consultants to assist them with the design of the works, and you'll be very familiar with the usual consultants, so architects or structural engineers, for example. The line between the employer and the professional team represents a professional appointment, and the form of this appointment can vary from project to project, but usually you come across standard forms. So, for example, architects tend to use the REBA standard form of professional appointment. One important party not on this diagram, so I'd like you to sort of draw it in your imagination, if that's okay, is sort of the end user of the building. So a purchaser or a tenant, for example. So maybe the employer is building the building to sell it on at a profit, or perhaps they'll keep it and lease different floors to tenants for a rent. And the line between the employer and the end users, that could represent sort of a land transfer or a lease, for example. So what I'm hoping you start to see here is actually where the lines are not drawn between certain parties. So there's no link between the funder and the parties in the blue boxes. Similarly, there's no link between imagined purchaser or tenant to those parties in the blue boxes either. But also there's no link between the employer who's running the show and the subcontractors at the bottom. And that's where collateral warranties come in, and it's to fill these gaps. So if we could move to the next slide, please. Thank you. So why do you need them? Well, it's to create a contract where there is none. Defective design or workmanship by the construction parties carrying out the design or works may cause other parties with an interest in the project to suffer a loss, either during the construction phase or after the project is completed. So, as mentioned, the employer will typically have a contract with the party responsible for the defect, for example, a professional appointment with an architect to design the new building, or the building contract with the contractor to build the building. But even the employer, as mentioned, will not have a direct contract with the subcontractors, and also third parties who have or acquire an interest in the building may not have a contract with those responsible for the defect. So a defect in the building will often adversely affect both its capital value and ongoing running costs. So a funder, employer, or purchaser may be concerned by a reduction in the capital value of their asset, while a tenant of a commercial building on a lease with a full repairing obligation may be concerned about higher running costs or service charges. So as a result, these third parties usually require some form of construction security. So, for example, a funder providing development finance to an employer will want to protect its loans so that if something goes wrong on the project, it can claim its losses from the person who actually caused the loss, so such as the architect or the contractor. If we can move slides, please. Thank you. So what is a collateral warranty? We're sort of covering old ground, but it creates a contractual link, essentially. But there is an important point with collateral warranties, and that is that it's a contract that's associated with another primary contract, such as the building contract or the professional appointment or subcontracts that we mentioned with the start. It's because under a collateral warranty, the warrantor, the person who's giving the collateral warranty, is warranting to the beneficiary that it has complied with and will comply with the primary contract. So they don't sort of work, so a collateral warranty doesn't really work independently. And this gives the beneficiary the right to sue the warrantor for breach of contract. So a couple of examples. So it can allow a purchaser, tenant or funder to make a claim against an architect if their design was defective, a claim against the contractor if the completed building was built defectively, or even a project manager if they've planned or coordinated the construction activities on site in breach of contract, which led to defects in the completed building. So if we could move on to the next slide, please. So who needs collateral warranties? Well, sort of covered it. So to summarize, they're the main parties there, but there's a point to note for tenants. So if you're a tenant taking a lease, you may not necessarily need collateral warranties. There are a number of reasons for this. For example, premises may not be new premises, so whatever collateral warranties were provided for past works will have expired. But also it's important to understand your lease and in particular your repair obligation. So if your lease is internal repairing, then the tenant will be responsible for maintaining things like internal finishes and fixtures, but it's the landlord who takes care of the exterior and structure of the building. So the tenant's really unlikely to ever need to enforce a collateral warranty if defective design or workmanship emerges, because it's the responsibility of the landlord. Can we move on to the next slide, please? So who gives collateral warranties? They're all there. I've mentioned them already, so nothing more to say there. Can we go to the next slide, please? So I'm just going to talk about some key clauses. I've already mentioned that a collateral warranty will include a warranty that the warrantor has complied with the terms of their primary contract. Where the warrantor has a design responsibility, so an architect, for example, you'd also usually expect the collateral warranty to include an obligation to exercise skill, care, and diligence in carrying out the design. Now, collateral warranties vary and different wording is used, and you come across different wording, but it's usually there, it should be there. A funder may need the ability to step in and complete the project itself if the employer becomes insolvent, for example, before the project is complete. So having step-in rights in their collateral warranty should enable them to step into that underlying primary contract if they need to, which is the building contract in that example. Every collateral warranty should have a fairly standard copyright license. Again, the wording varies, but it's always there. This will allow the beneficiary to copy documents and designs for use in connection with the property. If we can move on to the next slide. So it's just some more key clauses. Where the warrantor has a design responsibility or management responsibility, you would expect there to be an obligation on the warrantor to maintain professional indemnity insurance. Collateral warranties are fairly predictable when it comes to assignment rights, so right to assign. Most will allow the beneficiary to, sort of the funder, the purchaser or the tenant, to assign, which just means transfer, the collateral warranty to a third party. Usually 2 onwards assignments are permitted, and then any subsequent assignments after that would require the consent of the original warrantor. So, for example, a purchaser of a building who receives the benefits of a collateral warranty could potentially assign that collateral warranty if they were to sell the building on a few years later. Limitation periods. So that just means the period within which a claim can be brought, and that will either be 6 years or 12 years, depending on how the collateral warranty has been signed. So if you're getting the benefit of a collateral warranty, we recommend that you make sure all parties properly execute it as a deed. I won't go into how to do that, but that will confer the 12-year limitation period as opposed to 6. The last one, limitations of liability. So there are a number of different limitations of liability, and I don't have time to go into them all in detail, but just to give it a simple example, there may be a general financial cap on liability to say, I don't know, 1 million, and that seems fine at first, but if it's a £50 million building and a defect emerges which is such that the building has to be partially rebuilt, for example, then this financial cap is obviously not good news if you're hoping to enforce the collateral warranty and recover costs. So enforcement, I wanted to touch very briefly on this. How do you use a collateral warranty? Well, it's a legal contract, and therefore if defects or failures emerge in the building or the works, then it provides you with a route to claim against the warrantor for breach of contract and to claim damages. It's an important point to note is that to bring a successful claim, the failure or defect must have caused you to incur or suffer a loss. And then the final point there is just interestingly, there has been some very recent case law in July this year, which confirmed that collateral warranties are not construction contracts. And what I mean by that is construction contracts as defined in the Construction Act 1996. So this is an important point when it comes to enforcement, because the Construction Act provides for a statutory right to refer any dispute which arises under a construction contract under the Act to adjudication. So adjudication offers a faster and cheaper alternative method of dispute resolution, which is often viewed as more desirable than litigation. And until this year, it was widely accepted that a construction-related dispute arising under a collateral warranty could be referred to adjudication under the Act. But this has now changed, and it's unlikely that you would have a statutory right to refer a dispute to adjudication. There are ways now of drafting collateral warranties to make sure you can, but any that you come across from before this year are unlikely to be to have that. So last slide, I think. Yeah, so are there any alternatives? In short, yes, there are. You can see some listed here, but this slide is really just to make you aware that there are alternatives. And I think the details probably beyond the scope of this talk. And I think I've run out of time. Sorry if I've run over, Dave. I haven't really kept an eye on the clock. Thanks so much for listening. I hope you can take something from it. Over to you, Dave.
Luke, Aditi, as well. I was actually going to congratulate you on your wonderful timing. So don't apologise. I suspect you saw how many slides I had and voted for me to go last, but that was fair enough. So before we get to the next slide, Javaria, I'm just going to introduce the talk. So my name is David Bird. I head up our planning team across our many offices, and we work all over the country. So one of the things we've been looking at recently are the upcoming changes that the new government are bringing in, and they have just finished consulting on the NPPF, National Planning Policy Framework, which is the overarching guidance document that sits across all of planning in England and Wales. The first rule of planning, though, is that nobody truly understands it. It is so complicated. So if anyone is gripped by fear of imposter syndrome in their job, don't fear anymore. Have a dip your toe in planning. I don't really understand it either. I'm just reading out the slides. But anyway, together we'll try and unpick some of the proposed changes. Anyway, the background to these changes is probably quite well known. It's the housing crisis and the consistent underproduction of homes, probably across many decades now. The new government has promised to fix it and deliver 1.5 million homes across the 5 years of the Parliament. I think we can probably say they will fail. It's a standing start, really. We're already 4 months in. They just can't ramp up that quickly. They probably should have promised to get to a run rate of 1.5 million homes every 5 years. But unfortunately, they will not quite get there, I do not think. Anyhow, how are they going to do this? But for all the talk of grey belt, green belt, etc., the main driver to this is going to be a change to the housing targets. So let's have a quick quiz first. Next slide, Javaria, please. Okay, so the way to calculate housing targets in England is using the standard method, and which is going to be revised. So here's a little table. In the middle column will be the current method, and in the right-hand column will be the proposed method. And it will tell us how many houses for each of those regions in England. So next slide, please. So the region with the highest increase in housing target from the current to the proposed by the new government is the northeast of England, a whopping 99% increase. In absolute terms, that's actually not that many houses. The region with the lowest increase is going to be London. Famously, no one wants to live in London, so I'm sure that will be all okay. In a moment, they'll start looking at, to illustrate the problem in reality, actual net additions. Thanks, Javeria. So this is the rate at which these regions have actually been building houses compared to their current and proposed targets. So the region with the lowest increase in housing target over the actual net additions is East Midlands, only a 20% increase, and the region, probably unsurprisingly, with the highest increase proposed in their housing targets compared to the actual rate of house building is London. You can see the problem there. They are way behind, 114%. So next slide, please. We'll show you the whole country. It's all very busy. Let's just look at the bottom line, though. So the difference between the current method and the proposed method for calculating housing need is 22% across England as a whole. You'll see the problem, though. The rate we've actually been building them is much, much less, and it will require an increase of 62% from July 2024 to meet this. Right, next slide. To look slightly more locally, at least to me, I appreciate everyone's around here, Avon, the long dead Avon, but nonetheless, the problem here that can be seen is that the counties with the land, North Somerset and South Gloucestershire, are those with the lowest housing targets, and the counties without the land but with people are Baines, Bath, and North East Somerset and Bristol. So of those, one can see that South Gloucestershire has been making a valiant effort and in fact has been building more than the current method, slightly less than the proposed method. But the reason I'm illustrating this is that it's obvious. Baines and Bristol will not be able to find the land to deliver 1,400 and 3,000 houses, respectively, when they're only building 605 and 1,800. North Somerset and South Gloucestershire will have to pick up the slack. So how are the government going to do this? Next slide, please. So the MPPF, available online or printed in very large type for those with short sight, is going to be amended. There was a consultation, it's just closed in September. We're waiting to hear from the government what their response to that is going to be. So this is a document that sits over everything in planning. Local plans, those strategic plans for each county in England need to be made in accordance with this document. Also, it contains rules for those councils who are taking decisions as well. So individual planning decisions can also refer to the MPPF in their planning balance. Next slide, please. So what the first change we're going to look at is going to do is to ingrain the standard method into plan making. So formally, it said to determine the minimum number of homes needed, policies should be informed by local housing need assessment conducted using the standard method. That was the current method in those tables we looked at. It used to go on to say the outcome of the standard method is an advisory starting point. There may be exceptional circumstances. I think that every local authority went out their way to find exceptional circumstances so they didn't have to build the number of homes that probably the local residents would have been up in arms about. But that has been deleted. So now we've just got conducted using the standard method. You have no choice. In addition to your local housing need figure, any needs that cannot be met within neighbouring areas should also be taken into account. So this is where Avon is going to have to sort itself out. South Gloucestershire and North Somerset will not be able to do their local plan without taking into account the unmet housing need in Baines and Bristol. Indeed, both of those local authorities, South Gloss and North Somerset, have paused their local plan process to go back and look at this. Right, next slide, please. The changes go on to really embed cross-border working. It is a bit of a, I guess, a flaw in the way it works at the moment. We have hundreds and many local authorities across the country producing individual local plans, looking inwards, not necessarily outwards. So this new cross-border requirement is going to replace the duty to cooperate, and is more definite. So plan making authorities should make sure their plan policies are consistent with those of other bodies where there is a strategic relationship. Clearly there is in the old Avon area. Unfortunately, there's still a little bit of wriggle room here unless there is a clear justification to the contrary. It sounds a bit like, to me, exceptional circumstances, and no doubt many will be clinging to that. But let's see, it goes on. In particular, the plan should ensure that unmet development needs from neighbouring areas are accommodated. I think that is quite clear, though. Next slide, please. Oh, I should say before we look at paragraph 11, that the government has also said they are going to produce some more legislation. So there's going to be, as well as changes to the NPPF, some new powers, I guess. I think that regional mayors are going to be given stronger planning powers. So there is a WECA, a West of England mayor, and I suspect it's Dan Norris at the moment. I think he is going to have more power for strategic plan making to force the constituent local authorities to work together on this. Anyhow, the NPPF paragraph 11 is one of its main paragraphs, and it comes in two parts really. One applies to plan making, that's the once every 5 years strategic level, and the other half to decision making. So here we can see that for plan making, all plans should promote a sustainable pattern of development that seeks to meet the development needs of their area, and B, strategic policies should provide for objectively assessed needs for housing, as well as any needs that cannot be met within neighbouring areas. That's the third time we've seen that phrase so far. It really is driving it home, I think. Thank you. And the second part of paragraph 11 looks at decision taking. This means if you are making a planning application, you can appeal directly to this part of the NPPF to require the planning officer, or indeed the committee, to take account of what it says. And you might have heard this as the tilted balance, and that is where there are no relevant development plan policies, or the policies for the supply of land are out of date. They should grant permission unless I is to do with listed buildings and other things of particular importance. And two little I's is the bit we'll look at in a second. I should say that we'll look at next at the meaning of the policy being out of date. But unbelievably, there are still local authorities who have no local plan at all, some 20 years after they were supposed to have brought one in. So that the fact that there are some with no relevant development plan policies is really not helping. Anyhow, the change here in where you can show your local authority as an out-of-date policy for the supply of land, you can appeal to this and show that the adverse impacts of approving this development are not significantly and demonstrably outweighed by the benefits. And here, the government is focusing the attention of the local planning authority on the location, which I take to mean transport probably, and design of the development, and for securing affordable homes. If you can show good things about those three things, you are more likely to get your permission. Next slide. So you are out of date if you cannot show a 5-year land supply. I'm not going to go through this in great deal of detail, but there is also a housing delivery test, which is back. It was in, then it was out, and now it's back. So if the local authority has shown a consistent under delivery of homes against the target, then its housing target will be deemed to be out of date, even if the number in the local plan is correct. Next slide, please. Right, taking a break from housing ever so slightly. Looking at commercial development, the new bit here is appropriate sites for commercial development which meets the needs of a modern economy should be identified, including suitable locations for uses such as laboratories, gigafactories, data centers, etc. So if you are looking to develop one of these things, I do suspect that many local authorities would not necessarily think about hosting a data center or a gigafactory, which by definition are large things in their area. But if you can identify somewhere a site that would be good for this, or co-location, then I think pushing the local authority by pointing to this part of the NPPF, pushing the local authorities to make room in the local plan is going to be an awful lot easier going forward than it was before. Next slide, please. Other changes. So affordable housing is now got a greater alignment for social rent. I think that's probably quite a good fit for a Labour government. They have deleted or proposed to delete beauty from the NPPF. I suspect that was probably a pointless inclusion in the first place, because I noticed no difference in the housing, the beauty of housing over the last 5 years compared to the previous. So next, please. Touching upon transport gently, only to, if anything, to point out that not all these changes are well thought through. The change to transport here is that all transport should now be vision-led. So it's a vision-led approach to promoting sustainable transport. Significant impacts from a development should be mitigated through a vision-led approach. I do not know what that means. I don't think anyone does. If we got any local authority people here and you are wondering, I would produce a supplementary planning document called A Vision for Transport, get it approved and stick it on your website, and then force everyone to accord to that, because that's the only way I think you can have a vision-led approach. Next slide, please. Right. Back into some more exciting bits. Brownfield, green belt, grey belt. So brownfield, the change here is that this was heavily trialed, I think, in previous changes, never quite came in. There's a brownfield sites register that's already in force. The NPPF now says that proposals for development of brownfield land should be regarded as acceptable in principle. So I think you can appeal to that in planning applications directly. You can say that you can't oppose my development of this brownfield because the development, it should be acceptable in principle. It is the details that we should be looking at. Next slide, please. Greenbelt is where the fight is going to be over the next few years. I suspect this is not well worded yet. I'm hoping the government will tidy it up. But Greenbelt boundaries should only be altered where exceptional circumstances are fully evident and justified. So now they've given some guidance as to what exceptional circumstances include, and it includes where the authority cannot meet its identified need for housing. So that's going to require, I think, a lot of local authorities to look again. Next slide, please. When it comes to individual applications, there was an existing commitment in the NPPF to allow development in the green belt if it were infill, limited infill, or redevelopment of previously developed land. There was a limitation on that. The redevelopment should not have a greater impact on the openness of the green belt than the existing development. So if you had an existing development, let's say of two-story buildings, you're not going to go taller than that really without impacting upon that. That has been deleted. I think that means you can go taller now on development of previously developed land. The only test you've got now is not to cause substantial harm to the openness of the green belt. So I think you probably go substantially more taller and busier than before. Next slide, please. Grey belt is the new thing. Grey belt is land comprising previously developed land. Well, that's nothing new because that was already allowed. But any other parcels or areas of greenbelt land that make a limited contribution to the 5 greenbelt purposes. So this could be land that has not been previously developed, but is providing a limited contribution. I don't think anyone really knows what that means yet, but do note that things in SSIs and national parks, etc., are not included in this. Next slide. So in addition to previously developed land, which is already allowed, and infill, etc., grey belt land is not to be regarded as inappropriate for development where it would not fundamentally undermine the function of the green belt across the area of the plan as a whole. I think that is the key to getting things built. Fundamentally undermine the function of the green belt across the area of the plan as a whole. You're not looking just at the site. It's not undermining the function of the green belt at the development site. You're looking at the area of the plan as a whole. How is any one individual site going to undermine the function of a county-wide green belt? I think there's quite a lot of room there to argue. Next slide, please. Oh, that was in fact the last slide. How exciting. We do have some questions. So I think, Aditi, should we go back to you?
Yeah, that's fine. I'm just picking up some of the questions which you have put in the chat. So someone had asked, I've mentioned the possibility of including a last day rent review and why we would do that. So this is to ensure that if your tenant ends up staying on in the premises after the end of the contractual term, they would be contractually obliged to continue to pay whatever rent they were paying at the end of the lease. So it may have been that your last rent review before that took place 5 years later, and so they would continue to pay rent at a rate that was already 5 years old. If you add a last day rent review on the last day, you're bringing your rent up to market levels, which means that if your tenant stays on in the property afterwards, you're at least getting an extra bit of rent while you either negotiate to get them out or you're negotiating a renewal. I hope that answers that question. And somebody else asked, why is RPI not being used anymore and why it's being replaced by CPI? RPI is not being used anymore because the UK government decided that it doesn't accurately reflect inflation, and it can actually both overestimate and underestimate in different scenarios. It also apparently doesn't meet international standards as well. And so they actually withdrew the RPI status as a national statistic in 2013. And going forwards, they've announced that CPI will replace RPI in 2030, which is seen to be a better reflection of the current status of goods and services in relation to consumer prices as well. So I hope that answers that question on RPI. Goes without saying, if anyone wants to talk about any of this with me in more detail, please feel free to drop me an email as well, and I'll be happy to speak to you. And then someone has also asked in relation to heads of terms, should the EPC be referenced in the heads of terms? Yes, it can be. An EPC is available from, the gov.uk website, so it doesn't necessarily need to be referenced. We're working on the assumption that most properties have the appropriate energy rating for them to be let. And usually the EPC is provided by the agent to the buyer or tenant as appropriate at the end, at the beginning of the transaction. But by all means, yeah, the EPC rating can always be added as a note in the heads of terms so that it's clear to the buyer or tenant what they're getting. But this is something that we can always download at the beginning of a transaction anyway, and we would flag that to a client. And the same person has also asked about VAT. Should VAT be included in the heads of terms? Yes, if the property is opted to tax and the buyer is going to be paying VAT on the purchase price, or if it's let, they might not be. Yes, that can be included. What I was focusing more on is what is helpful in terms of a drafting perspective. So our drafting will always say that the tenant has to pay VAT on the rent, for example, and then whether they actually pay VAT on the rent is dependent on whether the landlord has opted the property to tax. But yes, by all means, in the rent section, it would say rent at a rate of X pounds per annum. In addition, VAT will be chargeable, or the landlord has not opted to tax and VAT will not be chargeable. So the more detail we put in the heads of terms, the clearer it is for everybody. Someone has missed my reply about RPI. You should be able to get a transcript of this as well, but I can always send you an email if that's helpful as well. I don't want to add on because I know we're short on time at the moment. Did anyone else have any other questions? For Luke or for David? I don't think so. There are a couple of questions in the chat box. These are all questions for me. Gosh, lucky me. ESG clauses and heads of terms. Yes, like I said, the more the better. I mean, sometimes it won't be completely relevant if it's a small transaction, but all this is good information to include. Someone has asked for views on uninsured risks. If there's a more specific discussion, I'm happy to talk to you separately about that if that helps. I'm not quite sure what you're getting at with the question, but feel free to get in touch and I'm happy to have a conversation. And then someone else has asked, should we be specifying specifically or negotiating the position on historic contamination, inherent defects, and insured and uninsured risks at the heads of term stage? In relation to contamination, if you're dealing with a site that you know might be liable to contamination, like if it used to be a historic factory or garage or petrol filling station, and you know that there is a risk that there will be contamination on site, yes, that is a really helpful thing to have agreed at the heads of term stage, because often the remediation costs can be quite high, and as a seller, you may wish to then pass on all that to your buyer, and or if you're buying, you may not want to take on any of that if you're intending to use the property for something completely unrelated. With insured and uninsured risks, I mean, as I said in the presentation, uninsured risks is something that is coming up more and more. And I think it just provides a framework for tenants to have certainty on what happens if the landlord hasn't insured against a particular risk, and what happens. Otherwise, you end up in a grey area where the property has been damaged by a risk which isn't insured. And then what happens? What happens to your rent suspension? What happens to termination? What are the landlord's obligations in terms of reinstating? Who pays for it? So yes, if that can be agreed again at the outset, that's always really helpful. I don't think there are any more questions for me. Oh, there's one more. As a tenant, would you still seek warranties if inherent defects have been carved out of the lease repair liability? That will depend on what exactly you're trying to carve out, and how much information you've been provided with upfront. If you've been given tons and tons of information and you're happy to take a view, and you're satisfied with what's been provided, that's fine. And if you've seen the relevant insurance policies as well, you could probably get comfortable. But again, this all depends on a case by case basis, and we'd be able to advise you depending on what the property is, and also it depends on the willingness of the other parties as well. But that's something that you would normally take on a case by case basis.